Mr. Gordillo, turn on your camera.
Yes, ma'am.
All right. Hello.
Good morning, Your Honor.
Good morning.
Your Honor.
Okay, you can, Mr. Gordillo, you may start when you're ready. And you want me to save you 5 minutes, sir?
Please, Your Honor.
Okay, I'll do that.
Thank you, Your Honor. With the appellant, I represent the Sheriff of Pinellas County, Poplar area in official capacity. This is a civil matter. 2 negligent claims were brought against the Sheriff's Office based on some child protective investigations. We filed a motion to dismiss this matter. We raised sovereign immunity. It was denied a dismissal, and we have sent appeal. The threshold legal matter prior to entering a sovereign immunity analysis is whether there was a duty of the Sheriff's Office to these children, and we contend there was no duty specific to these children. As to the Sheriff's Office, the duty to protect children is made to all children as a whole in the state of Florida. The duty to enforce the laws under Chapter 39 is also a general duty. That comes under Trine and Part as a Category 2 duty for which there is no common law duty of care as to any specific individual or persons. In this matter particularly, there was a call to the abuse hotline.
Mr. Gordillo, I am having some difficulty hearing you. Would you be kind enough to increase your volume, please?
Yes. Is this better? Is that better, Your Honor?
Yes, it is. Thank you very much.
Thank you. We received a call from the hotline in September 2016. Child protective investigation was commenced and concluded. A second call came in regarding these children and this family in December of 2016. At that time, we investigated, and under Chapter 39-301, we did find that there was some concerns for these children. And under 39-301, we are given the discretion, the option of either removing the children or initiating protective services. Services were initiated at that point in time. At this point in time in 2016, the Sheriff's Office handled the investigations for DCF in Pinellas County, and Eckerd Alternatives handled the services. So under Chapter 39-301, once that case staffing occurred, and once those services were initiated, the Sheriff's Office duty no longer existed. It ceased at that point in time, and under statute, it switched over to Eckerd, who then is responsible for providing services and the ongoing supervision of the children of this family. At that time, for this particular family, Eckerd had subcontracted out with Directions, who was providing the services and the supervision for these children for this family. Fast forward a few months later, in April of 2017, a third investigation is commenced based on another report to the hotline. At which point, Sheriff's Office comes out, investigates, and it's determined again, which again, discretionary decision to keep services remaining in the home. So again, once that investigation concludes, once those services continue, the Sheriff's Office duty ceases and the duty of Directions and Eckerd continues on. It wasn't until July, unfortunately, the father took some criminal actions, and the young child, the boy, the young boy, WH, his initials, ended up deceased on July 27, 2017, based on criminal actions of the father. During that time, Eckerd and Directions still had their ongoing services going on. And the day prior, Directions, one of their case managers or supervisors, went out to the home, saw some concerning behaviors of the father, saw some danger to his child, took no action at that time, returned later in the day with a police officer from the Largo Police Department, who again saw the conditions in the home, saw what was going on, Neither of them did anything at that time to remove the child from the home, anything of that nature, which they have discretion to do under Chapter 39. And a call is made to the hotline. So that would be the fourth investigation. By the time we initiated that investigation, the child, WH, the young boy, was deceased already. Therefore, we believe the threshold of legal matter is we had no duty at the time of this harm because directions and Eckert were the ones who had, under Chapter 39, the duty and the obligation and were conducting their supervision and their ongoing services in this matter. So based on that, we don't believe that we even get to the sovereign immunity issue because if there is no duty, there is no liability, and there is no claim against the sheriff's office. Going into the sovereign immunity argument, basically it comes down to.
Well, you take up most of your time talking about the duty issue by recitation of the facts. I mean, your opposing counsel is going to get up there and argue about Yamuni, and he's going to argue about a special relationship. You have anything to say about the plaintiff's argument that this that your client had a duty?
Yes, Your Honor. Yamuni is that case. Actually, if you look at the context of when that case was decided versus what was going on later on, Yamuni was decided in 1988. At that time, it wasn't Department of Children and Family, it was Health and Rehabilitation Services, it was HRS. And back at that time, HRS handled under one roof both investigations and services. It was all handled under the same department. In 1999-2000, there was a change made in Chapter 39, wherein 6 counties were mandated to take over the child protection investigations for DCF by 1999. Pinellas County was one of those. So from going from 1999-2000 forward, it was bifurcated. Pinellas County Sheriff's Office handled the investigations, and over time, the Department of Children and Family subcontracted out the services portion to other entities. 2016 it was, in 17 it was active. So under Yamuni, the problem in Yamuni is when you read the case, they're talking about the caseworkers and the services, not investigation, not child protection investigators. So there's a big difference between what happened in Yamuni and what happened here. Yamuni also talks about there has to be a case-by-case analysis and a minute examination of the facts of each case, because sovereign immunity isn't just a blanket issue, isn't a black and white issue. It depends very much on what's going on, what the facts are, what the circumstances are.
Mr. Gordillo, if the complaint seems to be rather detailed in its allegations, and of course we're here on a motion to dismiss. I just have a question: is this a better case for you, perhaps at summary judgment,
I don't
given the extensive factual allegations of the complaint?
I don't believe so, Your Honor, because the complaint, the Second Amendment complaint, is so factually detailed. It does lay out facts that the services are to be provided by Eckert and directions. That was their responsibility. That the ongoing supervision, monitoring, and safety plan was Eckert and directions responsibility. It also references Chapter 39 specific statutes that when you go and read them, tell you that once the investigation concludes, once services begins, the sheriff's office duty ends and the service providers begin, the lead agency, which was Eckert and directions. So based on the allegations, it's very clear what the facts are going to be at summary judgment because they're laid out so succinctly in this complaint, and they do detail that this was in fact directions in Eckert's case at all times pertinent. In addition, when talking about the day of the July 26, 2017, when directions went out and saw the conditions of the home, it very clearly in the Second Amendment complaint states that the case manager from directions failed to take duties to keep the child safe, which was their duty at that time, being it was their open case, it was their ongoing services. Getting back to the Yamuni, why it's so different from our case is in Yamuni, In January of 1980, services were court ordered. They were at a hearing, the mother was at the hearing, HRS was at the hearing, and at that time, the court ordered services to go into the home. That was a court order that they were no longer, wasn't a discretionary choice, it was you will put services in the home. The mother at that time agreed to accept the services. Yamuni then fast forwards to August of 1980, so 8 months passed. During those 8 months, the services that were court ordered and agreed to were never provided. And at that time, the child was injured, which leads to that lawsuit. And in that case, HRS said that they dropped the ball, they made some internal mistakes, there was a breakdown, and that's why the services that were court ordered were never provided. In our case, protective action was taken under Chapter 39. This now kind of rolls into the sovereign immunity argument. Discretionary choices, discretionary decisions, discretionary actions are immune from suit under sovereign immunity. Chapter 39 is very clear when an investigation is done under Chapter 39. If first discretion is there probable cause to believe that action needs to be taken? We didn't find that in September, we found it in December. Once it's found that action needs to be taken, there's also a discretionary choice of is it going to be removal or services? Again, that's a discretionary decision given to either DCF or the sheriff's office, depending which county we're in. That was done. Protective action was taken in December. And again, this occurrence didn't happen until 7 months later, after 7 months of continuous ongoing services and supervision by Eckerd and directions. So that kind of leads into
Mr. Gordillo, I know you're answering a question, but I just want to let you know you're at your time. So use it however you like. I finish answering the question, but.
Yes, ma'am. Very good. And just to make it very brief, and to sum it up to save my time, the other case law in our brief shows that whether to take into custody is a discretionary decision. That's the Whaley case. And we also raised, in addition to sovereign immunity, 39203, which is good faith immunity. When protective action is taken, we should be immune from suit. And that comes from the second DCA case of Doherty. It's also discussed in the Floyd case, with the Supreme Court case. I'll leave it at that and go out my brief, and I'll save the remainder for rebuttal. Thank you.
All right, thank you. Mr. Filson?
Yes, Your Honor, may I proceed? Yes, I am.
Yes, you may.
All right. Boiling it down, my understanding of the appellant's duty argument is that while HRS and DCF may have a special relationship with children for whom abuse reports are received, the Sheriff's Department doesn't. Historically, HRS did child protective investigations. Then those responsibilities were turned over to DCF when HRS went through its consolidation, breaking out the Department of Health and these other agencies. And then in Chapter 39.605, got that wrong, 3065, certain sheriff's departments like the Pinellas County Sheriff's Office in 2014 started undertaking child protective investigations. Yamuni, the Supreme Court in Yamuni was very explicit. This case was decided in 1979. So it's been the law in the state for 40 years, over 40 years. And the specific holding isn't tied to whether there's an order or the judge ordered something and it wasn't complied with, or whether the abuse happened during the investigation, or whether there's a proximate cause argument that the abuse happened after the investigation was closed many months later. The Supreme Court stated, quote, "We agree with the district court below that HRS has a statutory duty of care to prevent further harm to children when reports of child abuse are received," unquote.
But Mr. Filson, I don't see how you take into account the restructuring where it appears that only the investigative authority has been transferred to the sheriff. I mean, in Yamuni, you have a situation where HRS is a one-stop shop. They're doing everything. They're providing services, they're doing investigation. And that's not what we have because of the
Okay.
statutory changes.
Okay, and I'm going to do something I know that the court doesn't like, but I want to read from you, Mooney, the basis for the special relationship, because I think it really answers your question. In the immunity decision, I'm quoting, the HRS also argues it has no statutory duty under Chapter 827 Florida Statutes 1979 to prevent further injuries to abused children after reports of such abuse are received. And further, that Section 827.07 sub 7 statutorily immunizes HRS from liability. As we indicated above, it seems clear that HRS is being excessively modest concerning the importance of its role in preventing child abuse. Now, this is the important part. The HRS is not merely a police agency, and its relationship with an abused child is far more than that of a police agency to the victim of a crime. Chapter 827 designates children as a protected class of persons and requires all other persons with knowledge of suspicion of child abuse to report such abuse to HRS. Failure to report is a criminal offense under Chapter 827.07(18). Now, this is the part that's important. The HRS is assigned the responsibility or duty to provide ongoing protective services to and on behalf of children in need of protection to safeguard their well-being. So that's number one. Number two, this duty is reinforced by the statement of legislative intent that reports of abuse or neglected children be made to HRS in order to prevent further harm to the child. It cites a statute. This duty is further reinforced by the specific requirements for conducting child protective investigations in Section 827.10. It is clear from these various provisions of law that the primary duty of HRS is to immediately prevent any further harm to the child, and that the relationship established between HRS and the abused child is a very special one. So now you have two statutes. One is, and this is in the brief, 39.3065, which it's simply assigns child protective investigation responsibilities to the sheriff's office from DCF. And then 39, and this is also in the brief, 39.301, subsection 8, which is kind of short, says protective investigations shall be performed by the department or its agent, but 9A is the more important one. It states that for each report received from the Central Abuse Hotline and accepted for investigation, the department or the sheriff providing child protective investigative services under 39.3065 shall perform the following child protective investigations activities to determine child safety. Now, these aren't all alleged in the brief because it would have taken up, a lot of pages. It's got the laundry list in the statute I'll just conduct a review of all relevant available information. Number two, conduct face-to-face interviews with the child, siblings, parents, others. Then you get into number 5, complete assessment of immediate child safety. 6, document the present and pending dangers. 6A, implementing safety plans, such as in this case. You get, and then that paragraph is, multiple sentences of the things they have to do to develop safety plans and when it's appropriate, not appropriate. Exactly what we're dealing with in this case. B, collaborate with the community-based care lead agencies. For each report received from the Central Abuse Hotline, the department or the sheriff providing child protective investigative services shall determine the protective, treatment, and ameliorative services necessary to safeguard and ensure the child's safety and well-being and development and cause the delivery.
Well, Mr. Filson, if I may, typically, correct me if I'm wrong, it is somewhat rare to impose a special duty on law enforcement. That fair?
Yeah, and keep in mind, they're providing child protective investigations which are civil in nature. These aren't sworn deputies. This is a civil task that the sheriff's department has undertaken under the undertaker's doctrine. We need to go there. From DCF, they've assumed.
Is it a true undertaker doctrine? From your reliance on the statute, you seem to be suggesting that the sheriff's office has statutorily imposed duties to investigate.
and to provide safety plans and to
But that's in
determine.
conjunction with, the DCF.
No, that's in. Okay, let me go back to that again. Make sure I'm giving you the
I'm
specific.
sorry, but I thought the sheriff's office investigates once they get a report on the hotline. And at that point, they do their investigation and they have the discretion to either immediately remove the child or to coordinate with the agency for some safety plan or otherwise get the child out of the house to DCF or its
What the statute says is for each report received from the Central Abuse Hotline, the department or the sheriff
Yeah.
providing child protective investigation services under 39.3065 shall determine the protective, treatment, and ameliorative services necessary to safeguard, ensure the child's safety and well-being and development. And it goes on. And there's a paragraph after that and a paragraph after that. Everything that you brought up, okay, are they doing all the same? Are they required to do all the same things as in Umuni? Yes, more, according to the statute. And it specifically references the sheriff, the department or the sheriff, whoever's doing it in a particular county, and the statute 39.3065 from which this occurs. And keep in mind, I alleged in the complaint, not only the statute, there's also an interagency agreement, which is very detailed and has sets forth all the requirements that the sheriff is supposed to do, with the various agencies, et cetera. And we're tracking them. We're tracking that. You've also got an administrative code provision, which applies to anybody that's conducting child protective investigations when they impose these safety plans, when it's appropriate and not appropriate. These are voluntary, protective services type things. If the child's in danger, you don't do it. So no, I strongly disagree with that. The statute 39.301 treats the sheriff just like DCF. In other words, if you undertake that, in other words, you're one of those counties that has a sheriff's department, you're just like DCF when it comes to child protective investigations, when it comes to the specifically enumerated duties. This is from the statute.
Can I ask you about the enumerated duties? And this is just asking you to educate me, re-educate me, reacquaint me with what has happened and what how the procedure is to unfold. Those enumerated duties, did at any point, based on a discretionary decision by the sheriff's department, were they to be assumed by the contractors?
Understand the question. I'm sorry.
No. Okay. So not at any point, you said, well, there's all these enumerated duties. You said they were so long you couldn't even fit them in the brief. But at some point, was the obligation to provide those duties shunted to the contractors? At the time the sheriffs showed up.
Well, I suppose, certainly in every county, even forget the sheriff's department, DCF, has a can subcontract out a lot of its activities to privatized entities, for instance. And sometimes they do, and sometimes they don't, depending on the county. When you're up in North Florida in some of the smaller counties.
But so correct me if I'm wrong, those were not contractors of the sheriff's department.
No, they're not. They're not
contractors. Right, so then the sheriff's department, what the sheriff's department could have done and just was shunted back to a contractor of another agency. They don't do child
protective investigations.
No, but after the investigation was done,
they do case management. This is essentially what they're doing. They're doing they're going out, doing home visits, and they have their own duties. In other words, if they see a child getting abused in front of them, then they have a duty to report it. And there's an administrative code provision that in an extreme situation, a privatized case manager can pick up the child and walk out the door. That's extreme, but it can be done. So, you have a variety of defendants in this case, Judge. We're talking about the sheriff right now, but everybody had a role in what happened. It took a lot of people to mess up collectively for this one child to die and the other one to be severely injured. So I'm not, I don't want this played back by another defendant down the road, my oral argument today, but essentially they had a child protective investigation responsibility. It's not just a law enforcement function, it's a civil function. And there's a statute that lists all the things that they're required to do. So if we're talking about sovereign immunity, They had a statutory list of things to do, and a Florida Administrative Code list of things they had to do to make this happen, and an interagency agreement. I mean, I don't know how much more we could have to show that this was an operational act, that they conducted. Mooney was very clear about that. BJM and Whaley all approved of Mooney's decision, to impose this duty on in that case HRS, and that these were that the case manager, negligent investigations of a case, child protective investigator, are operational in nature. The other cases cited by the defendant, BJM dealt with allocation of services. It approved Mooney. I said operational caseworker decisions are not immune. Whaley involved a juvenile detention facility. Putting a child in another thing was not a child protective investigation. Nonetheless, it approved Mooney. Floyd was a lower court decision. It approved Mooney. So it's been, in fact, this court recently in a case that has nothing to do with this. I think I don't know if it's in the brief or not, so I better shut up about that. Essentially, I know you have in the past approved Mooney as well. So that said, in terms of duty, it's clear that they assume the same duties as HRS, DCF, and it's not simply going out and investigating and then determining whether or not a child should be removed. It's providing, them providing services prior to the case managers even getting in there. So that's point one. Point two, I think Mooney's clear on the sovereign immunity argument, that caseworker decisions, dealing with child safety, investigating a particular case, are not immune. The other two arguments that the defendant, the appellant made, proximate cause, I don't think that's appropriate, but I cited the Amore decision, which is another case where a child was left with the parent, and the boyfriend severely abused the child. That indicated that it's subsumed in Mooney, is the fact that proximate cause, was established. And finally, I think the section 39.203 argument they made that there was a affirmative defense, again, not really appropriate for a motion to dismiss, but clearly the immunity court, Floyd, and even Daughtry, that this court cited by the appellant, they were all overzealous cases. In other words, removing children when you shouldn't, not protecting children when you should. So essentially, that's my argument. If you have any questions,
Okay, thank you, sir. Mr. Gordillo, you have about 4 minutes left.
Thank you. Just to hit the brief highlights. It's interesting you're raising Mooney and talking about other cases that are approving it. BJM was a case, the Supreme Court case decided years after Mooney, in which sovereign immunity was actually granted. In that case, it was a placement decision by the HRS and services. Both those decisions, both the placement decisions and what services to provide and how they were provided, were given sovereign immunity under Trian in category 2 and 4 factors. The Whaley case is also interesting because in that case, sovereign immunity was granted. And that case in particular states that deciding whether or not to take into custody is entitled to sovereign immunity. What happens after you take into custody, if there's mistakes made, negligence, causing harm, that's not sovereign immunity. In this case, it's very clear we did not take these children into custody. We had a discretionary choice of services versus removal. We chose services in collaboration with experts. Going back to chapter 39, 39301, 9B does talk about, to answer Judge Rowe's question to Mr. Philson, that child protective investigators shall collaborate with the community-based care lead agency, and that community care agency will prioritize safety plan services to families. Then if you go down to subsection C of 39301, subsection 9C, it states clearly, the child protective investigator shall monitor the implementation of the plan to ensure the child's safety until the case is transferred to the lead agency at which time the lead agency shall monitor the implementation. The interagency agreement brought up by Mr. Filson, Florida Administrative Code and Florida statutes all state, once this case gets transferred, it is now Eckerd and Directions case. It is their responsibility to monitor, to provide the ongoing services. The quote he read in Yamuni, I just want to highlight the one piece of what he read. The HRS is assigned the responsibility or duty to provide ongoing protective services. That's what's at issue. This child wasn't harmed in September, December, or April while the sheriff's office was investigating. If that were the case, we'd be in a different posture. This happened months later in July when Direction and Eckerd's had the duty and the obligation under the Florida statute, the administrative code, and the interagency agreement to continue providing and monitoring services. That's why that discretionary decision made in December and made in April not only cut off the duty to the sheriff's office, but also provided sovereign immunity because it was a discretionary choice of whether to remove or institute services. If there's any questions, I'm going to.
Thank you. That concludes this argument.
Thank you.
Thank you.
Thank you both.